Welcome to the panel called the National Popular Vote Compact in the Electoral College, End Run or Dead End. This panel is much more of a continuation of Larry's lunch remarks in terms of types of reform and pros and cons, as opposed to the first two panels this morning, which were coming off of some upcoming books. I'll just briefly mention the panelists. Amel Ahmed is from the University of Massachusetts-Amherst, Derek Muller from Pepperdine School of Law, Reed Hundt from Making Every Vote Count, and Richie from FairVote. What I've asked them to do is, first I've asked Rob to take 2 minutes and just kind of describe the details of how the National Popular Vote Compact is meant to work. And then I've asked them to address one or all of the following three questions. What is the problem that National Popular Vote is trying to solve? Are the constitutional issues potentially lurking in National Popular Vote too large to make it insurmountable? And more generally, what is the best path to electoral college reform if the electoral college should be reformed? And the reason to focus on National Popular Vote is that it seems to be the proposal that, at least over the last decade, is the one that has gotten the most traction. We'll hear the details from Rob, but right now there are states representing, I think, 196 electoral college votes. The plan would go into effect once states representing a majority, 270, would opt in. The first 190 is always the easiest electoral college votes to get. So it may get a little more difficult coming up, but it does seem to be the proposal that's been the furthest advanced. And so I've asked each panelist to speak for about 12 minutes, so we'll have some time for discussion. We're running a little bit late, so we want to keep the panel on time, but I'm giving Rob those extra 2 minutes, so take it away, Rob.
Okay, great. Well, thank you. This has really been a terrific conference, learning a lot, fun to engage with people. I had a flow that I was going to do where I was going to like weave in a description of the compact in the middle, but I'll just sort of get that done clearly and I hope effectively. We've heard a lot about the winner-take-all rule, Larry's presentation, and so on. So just as a reminder, that was not talked about at the Constitutional Convention. It was not argued in the Federalist Papers. It was used by 3 states in the first presidential selection process, and then they abandoned it within 10 years. So like it wasn't sort of the thing that you were going to do, like give all your electoral votes to the popular vote winner in your state. But that's key to remember sort of what we're replacing. Like we're not replacing the Electoral College with the National Popular Vote Plan. We are changing a state rule that actually was not contemplated really by the founders. So that's what the National Popular Vote Compact is designed to do. So it's an interstate compact, which is a constitutional power that states have to be able to enter into binding agreements with one another. And that's very key because they're acting in concert. And what they're doing is that every state has their electoral votes, and they are, instead of doing the winner-take-all rule by state, where whoever wins the popular vote in their state, they're saying, no, we're going to award our electoral votes to the winner of the popular vote in all 50 states and DC. Meaning that whoever wins the popular vote across the entire country, all 50 states and DC, one person, one vote, will get all of their electoral votes. The slate of the presidential candidate that wins the popular vote, it'll be that person's slate. There was sort of discussion earlier about the sort of challenges of making this a priority. And the politics of reform when you have to deal with jobs and the economy and social issues and so on. More than 3,400 state legislators have endorsed or voted for the National Popular Vote Plan. It's been introduced in all 50 states. It has been debated and passed legislative chambers so that it could pass in 15 states and DC and have governors, sign it. It has passed in a number of additional states. It has been given attention in the way that the Constitution allocates or sort of delegates to states to make this decision about what to do with their electors. It has been taken very seriously and is a very serious effort, and Make Every Vote Count is working on it. We started with that effort back in 2004 when we first talked to John Koza, whose name has come up a couple times. John Koza is the architect of the National Popular Vote proposal, runs a group called National Popular Vote, lead author of a book called Every Vote Equal. I have this handout at the back that sort of tightly introduces all of this, that has been used and presented across the country and has really been making a big difference. I guess sort of getting to some things that I wanted to sort of attach to this conversation is that we're not seeking perfection, we're seeking a more perfect union, right? So that's part of the constitutional, or sort of the American ethos that goes right into the Constitution, that we're seeking a more perfect union, and we're never going to get there, but we keep that trajectory going. And I think that's one of the things we have going for us, is that principle about all people are created equal, government of, by, and for the people. These are core, and ultimately gets us to the right place. Not always as quickly as we want, but we've generally moved in the right direction along the way. And I would say inevitably we will make this change. Like, I don't accept that the current system is sustainable and it's just too hard to change, because it just is incredibly bad. I think one of the things I was just thinking of, like, what's the worst thing to say about the current system? But so there are more than 2/3 of states, the same states, that have not had a presidential candidate, for major party candidate, for nominee for president or vice president, campaign in a rally trying to get votes in a general election in the last 3 months of the campaign since 2000. Nor has there been a single campaign television ad out of all those millions of ads that are purchased targeted to any of their voters for almost 20 years, and it's not going to happen next year either. So someone was saying, the battlegrounds change. The battlegrounds shift a little bit, but Michigan was already a battleground, right? And Trump won it for the first time a Republican had done that since '88, but it didn't shift, the 34 states into play, and that's not going to happen. That's just not sustainable to me. So I think that one of the things that sort of where I start with is, let's look at things that get us better. And I think, Larry's point about, he's not looking for perfection in his amendment, but something that might work. And I think that's where National Popular Vote has been really exciting as something that's moving, but that's sort of what it's fixing for me. So there are a lot of objections that come up, right? It's sort of the what ifs and the whys, and we've talked some about them. One of the ways I always first think about it is, well, how does it compare to what we have? Is it worse, or is it actually equal or superior? And usually it's actually equal or superior. So people say, what about recounts? How could you ever do a recount? Well, actually, in the current system, under the current regime, it's incredibly difficult to do a recount. If Ned Foley was to talk about getting one done in Ohio in time, if Ohio was the Florida, not going to happen, right? And that's actually more likely to determine an election right now than what would happen with a national popular vote. And you sort of can go through this piece by piece. But it doesn't mean it's perfect, and also doesn't mean that we have to sort of accept, this is the only thing that could be done. And so one of the things that I wanted to bring to this conversation is some ways that I think that we could keep building on the compact. I would, to be absolutely clear, I'm a co-author of Every Vote Equal. I'm for the compact, and I really hope it passes, and it's just remarkable the progress that it continues to have. But I also think we can have conversations about making it better. And so one of the, there's sort of a bucket of concerns, and there's sort of legal concerns that this panel is mostly going to be addressing, that I think actually that sort of standard of how does it compare to the status quo is a very useful measure, because a lot of the arguments I think could be applied to sort of aspects of the status quo, in fact, have been tried and have failed. But, the plain language, just to make sure we've all been hearing it, but, Article 2 says each state shall appoint in such manner as the legislature thereof may direct a number of electors, and it sort of goes from there. So it's like the manner of how they set it up in this interstate compact is what all these thousands of legislators have been debating and deciding to do. And certainly I think our founders would be sort of flipping in their graves if they thought that we'd be just sort of reaching for some standard or another to reverse this delegation of authority that they had given to states. That it's really hard to kind of get to the point that it will be there eventually where the compact will pass 270. But there's a whole debate about whether it needs congressional consent. And sometimes people say, well, it needs congressional consent because it's a compact. And you know, you shouldn't pass it because it doesn't have congressional consent yet. Well, you know, the congressional consent comes after usually. And that's a normal procedure. And if it needs congressional consent, well, then get congressional consent. If some other thing needs to be fixed, then we can still fix it. There was a really interesting law review article by Vikram Amar in the Georgetown Law Review, where he sort of suggested a kind of a fascinating statutory idea about what we could do to address some of the, I think what I would say the leading concerns are about the compact. Now, that his suggestions, I think, would be important to review, and he's a great thinker, and these are sort of putting them out there. But what he was suggesting is that Congress, or based on the current powers it has to regulate the electoral process, which is established in Article 2, Section 1, sort of oversight of the procedures with how the electoral, you know, the date of when the Electoral College convenes and so on. That gives them a certain authority. Burroughs versus U.S. in 1934 established that there's a congressional authority to ensure the integrity of how states hold presidential elections. So to build on that, to say, okay, well, the compact has been passed, let's consent to it, and let's establish certain national norms for voter eligibility, election administration, recounts. That could be a fascinating conversation, and it would be debated about whether it is illegal, but it certainly is a way. He makes a convincing case that I think it is, but it's also a way to kind of address some of the concerns people have about what does it mean to have different voter eligibility across the states. One of his proposals, which is sort of dear to my heart, for those of you who know what FairVote does a lot of work on, is about ranked choice voting. So we've heard some about ranked choice voting today, and Ned's new book is sort of elevating it as a suggestion about how states can act to ensure that candidates who are winning electors in states under the winner-take-all rule at least are winning a majority rather than a plurality. And just as a reminder, Maine has actually passed this. It's going to be used next year. And they're going to count actually 3 presidential votes in Maine because they have a congressional district system. So it'll be Congressional District 1, Congressional District 2, and statewide will all have ranked choice voting tallies to determine the electors in what's effectively is one of the closest swing states in the country now. And so it really can make a difference, and it's something that I think state after state can do. So how does it fit in with the compact? That's, given I've been working on these issues together for years, people have wondered, do I have a solution to that? Because the compact seems to suggest it's going to be a plurality system, right? The candidate with the most votes wins. So one, the Vikram Amar article suggests that in that national statute law, the sort of implementation statute, that Congress could actually set up a presidential ballot that was a ranked choice ballot and actually set up a way to do ranked choice voting on top of the compact through a congressional statute. That way, you would actually have a singular electorate for president using ranked choice voting. We are, by the way, sort of that issue is something I worked on for years. It's going to be, we hope, on the ballot here in Massachusetts next year, used in a number of presidential primaries next spring. We're getting to a point where all the voting equipment companies are getting just ready to implement it and developing common data formats and so on, so that is becomes a very practical way that we could actually do that. What do we do until, so what if that doesn't work, right? And I'm almost like, oh, well, if that doesn't work, then you can't do anything. Well, there's other ideas out there, and I'll just sort of allude to the one I'm going to sort of play out more in their article that I will be doing associated with this conference, is that there can be a ranked choice voting presidential election compact built on top of the National Popular Vote Compact, so that states that have begun to pass it for their presidential elections could ultimately coordinate their count and generate kind of a collective ranked choice vote out of their state. And that's something that some folks with the National Popular Vote team are quite interested in also. So just as a teaser of sort of a way that we can keep working toward this more perfect union.
Thank you. And I was remiss when the panel started. I should have thanked Margaret and the Law Review for putting this together. It's a really great opportunity to talk about these issues as I think public attention is shifting to this question. And we're going to turn to Amel. Or Derek, would you rather go first?
Oh, sure. All right. Well, thank you so much for inviting me to this distinguished panel and this conference. I have 5 children between the ages of 3 and 12, and that means I've spent an extraordinary amount of time over the last decade reading children's books. One of those is Laura Numeroff's classic tale, If You Give a Mouse a Cookie. You've read it. The story follows a child who makes the ill-fated decision to give a mouse a cookie, which means the mouse demands milk, which means he wants to look in the mirror to see if he has a milk mustache, which leads page after page in a continuing comical exhaustion of chains of events around the home. And so the opening line of this talk might be, if you tell a mouse you want to hold a popular election for the president, you might ask what the rules of that are. And to that end, we're going to start talking about the questions for that. The notion of holding a popular vote for the president of the United States is, in theory, an intuitively simple idea. We hold popular elections for the governor of each state. We hold direct elections for basically every other office, from United States senator to local dog catcher. We even elect judges in many states. The National Popular Vote, the NPV, is fundamentally about changing the existing system, where the winner of the Electoral College wins the presidency, to a system that more closely resembles these other elections. It turns the Electoral College into a mechanism by which the winner of the aggregate total, the popular vote in the 50 states and the District of Columbia, becomes the winner of the presidency. Its purported virtue is it does so without the onerous need to go through the constitutional amendment process, 2/3 of both houses of Congress, plus legislative approval in 38 states, as you heard from Larry Lessig at lunch. Skip all that. Just get to 270 electoral votes worth of states, and you're done. I've entitled this talk, The Electoral College and the Federal Popular Vote. That's because any talk of a quote-unquote national popular vote is a misnomer at best and an outright lie at worst. The only existing mechanism we have to compile voting preferences is federal, not national in nature. The only way to create a national popular vote is nationwide regulation at the congressional level, which the current Constitution does not authorize. That means a constitutional amendment is the only means to determine a national popular vote, and that in turn suggests the NPV should be abandoned. James Madison's Federalist 39 makes the case that the new Constitution is Republican in character. He rebuts the contention of anti-federalists who claim the Republican government must be exclusively federal in form, that is, a confederacy of states, and that the Constitution is too national in character. Madison walks through various provisions of the Constitution to identify how in some forms it's national and in others it's federal. For the election of the president, Madison notes that it is mixed in character. He writes, the executive power will be derived from a very compound source. The immediate election of the president is to be made by the states and their political characters. Votes allotted to them are in a compound ratio, which considers them partly as distinct and co-equal societies, partly as unequal members of the same society. The eventual election, again, is to be made by that branch of the legislature, which consists of the national representatives, but in this act, they are individual delegations. From this aspect of the government, it appears to be of a mixed character, presenting at least as many federal as national features. When the people choose presidential electors, the function is national in character, like the choice of members of the House. The allocation of electors is based on population and in the sovereignty of the states, like the House and the Senate. The state legislatures have plenary authority to choose how to direct the appointment of presidential electors, what Madison describes as the political characters of the states. That's a process that varies state by state, but today, all 50 states and the District of Columbia direct the appointment by a popular vote. So it's quite tempting to look at the actions of the 50 states, which are pretty much in agreement these days, and think we've got a national popular vote. True. We can compile a nationwide total of the popular vote, but it is not a national popular vote. Federalist 39 is a useful reminder that our presidential election system is partly national and partly federal. And as we begin to look at vote totals in the United States, the federal elements begin to appear. Professor Norman Williams calls this the myth of the national election. And I've written about this as invisible federalism, the hallmarks of elections from each state and the hidden distinctions between them that make them distinctive contests. Barry Burton alluded to some of these earlier. Voter eligibility is determined by state. Incarcerated felons can vote in Vermont and Maine, but nowhere else in the country. States like Iowa and Kentucky, felons are permanently disenfranchised, even after completing terms of parole and probation. Mental capacity provisions vary from state to state. While no state authorizes children to vote, there's nothing that prevents them from doing so in the future. Some states have experimented with youth voting in local elections. Non-citizens have the right to vote in some local elections too. Adding vote totals then is not reflective of a singular popular vote. It is reflective of a series of independent vote totals state by state. Residency restrictions differ from state to state. Suppose you vote early in Colorado, move to Arizona, and cast another vote there on election day. Under many state laws, that's perfectly legal. The choice of presidential electors in Colorado is a distinct contest from the choice of presidential electors in Arizona, even though it appears you voted, quote unquote, twice for president. Voting procedures can vary wildly from state to state too. Some have strict voter identification laws and others have none whatsoever. Some are open at different hours. On the West Coast, the polls are still open as millions of vote totals are reported from the East Coast. Some have early voting, some have very little absentee voting whatsoever. Ballot access standards vary. In 2016, Green Party nominee Jill Stein and independent candidate Evan McMullen, among others, appeared on the ballot in only some states. States like Texas have extremely early ballot access deadlines and prevent late entrants from joining the race. There was an effort to keep Donald Trump off the ballot in 2016 in Minnesota for a filing error. And there are returns, subject to other constitutional considerations, to keep him off the ballot in 2020 for failing to disclose his tax returns. Ballot content varies from state to state. Imagine a hotly contested Senate election in one state, but none in another, or controversial ballot initiatives on affirmative action, gay rights, or marijuana on the ballot in one state driving up turnout. Counting ballots, from stray marks to signature matching, can vary. The ranked choice voting might be implemented in some states, but not others, and recount laws can vary from state to state. This is a crucial point I'll elaborate upon briefly. Most states have automatic recount provisions if the election is particularly close in the state, say within a quarter percentage point of the votes cast, separating the winner from the loser. Others allow a candidate to file for and maybe pay for a recount if the election is a little less close. But many states don't allow a recount if the margin is particularly large. Imagine we had a nationwide popular vote total and that nationwide total is close. We'd want to recount everywhere. Practical problems? Certainly. But legally, in many states, there would be no legal authority to recount unless the states change their statutes. Why? Because races in the state might not be close, even if it's close nationwide. State laws refer to state election results, not to nationwide vote tallies. Let me put this in alternative terms. Imagine a gubernatorial election here in Massachusetts. Imagine the Democratic candidate was on the ballot in Barnstable County, but not in Essex County. That incarcerated felons could vote in Middlesex County, but no one ever convicted of a felony could vote in Suffolk County. Imagine the polls were open till 6 p.m. in Worcester County, I assume I'm pronouncing that right, but 9 p.m. in Norfolk County. That is the national popular vote. The system seems unbelievable in Massachusetts because we couldn't fathom such disparities when we're voting for the same office. If it's a single constituency election, that is, we're all as a nation voting for the president, there should be some uniformity of rules. Now, we do, I concede, have variations from county to county in single constituency elections. There are different races on the local ballot. There are different ballot formats or different ballot marking tools exist. Think Florida in 2000 and how only parts of the state had punch card ballots. Today's early voting means that some counties prepay for postage for absentee ballots and others require you to supply your own postage. Signature verifications differ across jurisdictions, and even the most uniform of standards are subject to human error, and they vary as humans staff each polling place. At a theoretical level, then, we need to consider how much uniformity and equality we want in our elections. Essentially, we need a definition of fairness in election rules. And on top of that, we need not just a definition, but we need to ensure that we can unify those standards so that similarly situated voters are treated similarly. The MPV is utterly silent on this issue, and indeed proudly silent, because it wants to emphasize that states are free to continue to engage in their elections as they've done in the past, that the MPV is no dramatic change to the status quo. It places few conditions on state behavior. States need to recognize the results in other states. They can't withdraw from the compact 6 months before Inauguration Day, and so on. So could Congress provide that uniformity? It would be one thing if we had disparities and Congress could step in, but the Constitution provides little flexibility for those rules. Congress may determine the time of choosing electors. That's it. There's no manner power, unlike congressional elections. There's no power to dictate the rules of voter eligibility. The Supreme Court has in a past era construed the Constitution to offer broad powers in the Constitution over presidential elections to enact criminal statutes to protect the existing structure, to prevent fraud, corruption, and bribery. And with all due respect to Professor Vicamar, it's another thing to say that Congress has new powers to provide for uniform election rules in presidential contests after the states have passed new laws pertaining to them. Making Congress's power contingent on state behavior seems backward, not in the sense that Congress can supersede or invalidate improper state laws, but that it might expand upon its own federal authority to pass new laws. And it's not simply the absence of congressional authority. Professor Larry Lessig mentioned at lunch, Bush versus Gore, to the extent we can talk about that case seriously and not as a one-ride ticket, emphasize that similarly situated voters must be treated similarly, or we risk running afoul of the Equal Protection Clause. Recounting votes under one methodology in a few counties, but not counting them elsewhere being the issue there. And we can talk about other legal issues maybe in the Q&A. It's worth considering that the last serious constitutional amendment effort to abolish the Electoral College in 1970, by-seller amendment, the amendment's draft language says that the voters in presidential elections are fixed. They're defined like those for the House, those in the most numerous branch of the state legislature. The constitutional amendment would have permitted Congress to establish uniform residency requirements. While the states could establish the times, places, and manner of elections, Congress would be empowered to override those rules, including the manner of holding elections, which would extend to Congress enacting rules from ballot access rules to polling place hours, much like the Elections Clause for Congress. The end of If You Give a Mouse a Cookie includes an exhausted child sitting amongst a pile of cookies, milk, crayons, and cleaning supplies, a house turned upside down from a seemingly simple task. Maybe we want to have this conversation. Maybe we can roll up our sleeves and bargain through a series of rules. Maybe once we do that, we can draft the constitutional amendments framework to empower uniformity on these rules. I know Guy Charles in the back has thought extraordinarily well about how we can think about a truly national election system and what that framework might look like. It is these questions that must be an essential element to any inquiry to change our presidential election system. It is hard, transformative work, and there is simply no shortcut. Thank you.
Thank you, Derek. And next time, I don't want you to hold back. Amel.
Thank you. Is this on? Yes. So like Sam, I also had slides to present here. Unlike Sam, they are not available online anywhere, so you will have to take my word for it. And I will try to characterize the tables and other charts to the best of my ability. So I appreciate the opportunity to present on this panel. I often found myself in these discussions as a bit of an unintentional iconoclast because I am a defender of the Electoral College, or I think I might be one of the remaining people on the left who is still defending the Electoral College, or at least saying, not so fast. Let's think about this and let's try to actually figure out what the problem is and whether or not these solutions will address those problems. I think part of it is perhaps that I come from, the approach that I come from is one of comparative electoral systems. And while the Electoral College is idiosyncratic, I think it's safe to say that there are as many electoral systems as there are electoral systems. The variation is really quite large. And the determination of whether or not something works is not really a technical determination. Oftentimes it's a political determination, and I think that's what it comes down to here as well. So I'm an institutionalist who doesn't really believe in institutions, or I don't believe that they work in the way that often is assumed they work. So I don't think when institutions work, it's not because of the mechanics, it's because of the politics. And so that's what I tend to focus on. So in organizing my thoughts today, I have so much to say, and I think often because I do take a different position than a lot of people on these issues, I can be tempted to try to respond to every single point that's made. But instead, I'm trying to organize my thoughts today around one of the questions that was posed, which is, what is the problem that the National Popular Vote Compact is trying to solve? And I think it addresses many of the problems that have been brought up here. It addresses the issue of minority presidents. It addresses the issue of swing voters. But most importantly, it addresses the potential discrepancy between the electoral vote winner and the popular vote winner. And while it does all of these things, I think the last point is what it's uniquely suited to do. And so this is the point that I'll mostly be focused on here, the discrepancy. And the arguments in favor of the national popular vote are, in my reading, they're predicated on two claims. One is an empirical claim. The empirical claim is that the functioning of the Electoral College causes this discrepancy. And the second is a normative claim. And the normative claim is that there should be no discrepancy, or that the popular vote should always prevail. And I think both claims have some significant flaws. And with respect, so I'll spend most of the time focused on the empirical claim because that's what a lot of my empirical work on the Electoral College has been focused on. What is the source of the discrepancy? And I think here, as a starting point, it's important to distinguish what the Electoral College causes versus what it allows to happen or what it allows to manifest. And I think those are two very different things. So in trying to understand the source of the discrepancy, I think there are often claims that the system is just fundamentally broken, that it allows these things to happen, it's fundamentally broken, or that it's causing these things to happen. And so I start by looking at the historical discrepancies. We know of the four notorious cases, 1876, 1888, 2000, 2016. So those are the four cases that I deal with, separated by about a century and clustered. And so in my mind as a historical institutionalist, I look to, my first question is, why doesn't this happen all the time? If the system is broken, why doesn't it happen all the time? Why doesn't it happen half the time? Why doesn't it happen more frequently? Why does it happen at the times that it happens? So that's what I'm really trying to focus on here. And what my mind has gone to is trying to identify the environmental conditions that might be driving this. And it's already been pointed out, and I think Sam's work is really interesting on this front, that even these four occasions are statistically significant when you look at the fact that they are taking place during highly contested elections, very competitive elections, and during times of high polarization. And so in his reading, that makes it an even bigger problem. In my reading, that actually helps to identify what the determinants of the discrepancy are. So looking at these two periods, we know that they are periods of very high polarization, and they're also periods of party system flux. And those two things, I think, are significant. And so in trying to identify what the actual culprit here, what I've been looking at primarily is changing political geography and how that corresponds with changing party strategies and how that might actually be driving the discrepancy. In terms of the changing political geography, this is something that we have been paying attention to for some time, that there is particularly a growing urban-rural divide within the United States. And most people date this starting in the Voting Rights Act and shifting party systems around that time. But the changes in political geography, first I should say that this urban-rural divide has characterized European party systems since the early 19th century, but it has been held back in the United States primarily as a function of the racial cleavage, as that disrupted the emergence of the urban-rural divide. That comes about in around 1965. And so we've got a growing urban-rural divide that most scholarship tells us is not the result of self-sorting, which is to say it's not that Democratic voters are moving to the cities and Republican voters are moving to rural places. Number one, people just don't have that much mobility. Socioeconomically, it's very difficult to move. People do move, and that would disrupt things quite a bit. But it's not, the fundamental dynamic is not self-sorting. What most of the research has focused on are party coalitions and the shifting party coalitions around geography. The logic being that parties are increasingly playing it safe with more homogeneous coalitions, where the Democratic Party is primarily focused on urban centers and the Republican Party is primarily focused on rural centers and very reluctant to break out of these coalitions. Now, trying to identify coalitions has become increasingly difficult because parties are organized differently now than they used to be. But it is possible to track things like campaign spending and where parties are investing. And the general thinking is that the Democratic Party especially has been very focused on urban centers, hoping that through this, the heavy reliance on urban centers, they can flip swing districts. And I think this is what's really significant here. So it's really a combination of political geography and party strategy. And I think both parties are doing the same thing. So both parties are seeing narrower and narrower coalitions, but it's going to affect the Democratic Party in much more obvious ways because their reliance on urban centers is a really unstable strategy. Urban centers are the demographics change very quickly, and it's much harder to calibrate an urban strategy than it is a rural strategy. And we see this So far, I've been looking at 2000 to 2016 to identify what the source of the discrepancy is in these cases. And what I've been able to identify is between 2000 and 2016, with respect to urban-rural coalitions, the Democratic Party's coalitions have narrowed from, the numbers I've come up with are 47% in 2000, were 47% was the average rural percentage of rural voters in Democratic districts. And that's narrowed to 37%, which is a fairly significant narrowing of the electorate. Republicans have actually stayed quite constant. So the strategies are affecting the two parties differently. So we should expect to keep seeing this happening with respect to the Democratic Party. So to pull this out of the weeds a little and to understand, why this is important for us, what is actually driving the discrepancy is that this urban strategy is really hard to calibrate, and I believe that Democrats are overshooting their strategy in urban centers, and that's what's producing these wasted votes. And to pull it back even farther from that, I think what we're actually seeing is party weakness. Much of this is a function of party weakness and parties that are unable to broaden their coalitions beyond these really narrow windows. And the effect is much stronger for presidential elections than it is for House elections. So there is a general dynamic of party weakness that corresponds to a narrowing of coalitions. So going back to the national popular vote and whether or not this is the answer. Is electoral reform the answer? So let's say that this is our changing political geography. This is the situation that we are dealing with right now. Why not move to a popular vote? Why not, just short circuit these changes and allow the popular vote to manifest itself? My view on this is that it's really a technical solution to what's fundamentally a political problem. And it's going to exacerbate the problem. If the problem is being driven by party weakness and we move to a national popular vote, that only exacerbates party weakness. Now, there are other formulations, and I haven't really puzzled as much over Larry's proposal yet and the claim that it will not weaken parties. But there is no doubt in my mind that moving to a national popular vote is going to weaken the parties. And it's not primarily because of third-party challengers or new parties coming into the system. There are plenty of multi-party systems with strong parties, but those tend to be embedded within a broader system of proportional representation, and within those systems, parties derive a different source of power. But opening it up to a national popular vote without proportional representation is a formula for weakening the parties very systematically at a time when they're already showing signs of weakness. And so I'm going to try to wrap it up with a few reflections on the normative side of things. And so I believe that there are general pitfalls with a popular vote. I also believe that, I think I have trouble oftentimes because it seems that to others the popular vote is an obvious thing, whereas in my mind it isn't. And what I mean by that is I don't think there's anything natural about the popular vote, or any vote. Votes, or any of these votes are a function of party mobilization, they're a party strategy. There's nothing natural about them. You change the architecture of the system, you're going to have a different way of mobilizing the votes, and that won't be any less constructed, that won't be any more natural. Votes are not a naturally occurring thing, popular or electoral. The final thing I'll say is on the question of democratic stability and electoral reform. And I think even just within this symposium, there is this tension that I hear very often beyond the scope of this discussion, whether democracy should be conceived of as a destination or as an equilibrium. And those two things are very different, and they suggest very different approaches to perfecting democracy. So democracy as a destination is, it's a view that I'm critical of because it seems to fall into this historicism where democracy is moving along a path of greater inclusiveness, and every democratic reform you add onto it is going to make it inclusive and perfect it even more. I tend to think of democracy as an equilibrium. And if you don't like the game theoretical connotations of that term, you can think of it as an agreement. Democracy is an agreement to play a game according to a certain set of rules. And so my primary hesitation with respect to the National Popular Vote Compact is that it's attempting to change the rules without changing the agreement. This kind of end run, I think, is destabilizing and potentially quite dangerous. So in terms of what reforms I would support support a constitutional amendment. I would support the process by which we would build a consensus towards that. But anything that short circuits the game or the agreement that has produced that game, I think is potentially dangerous and destabilizing.
Thank you, Amel, and now we'll turn to Reed.
I think I'll stand up if you don't mind.
I don't know if that mic is on, so.
Yes, it's on. I had a jury trial once in which the jurors submitted to the judge a little note that said the mind could not absorb what the seat cannot endure. So with that in mind, I'm Reed Hundt. I'm here from the entertainment capital of the United States, Washington, D.C. It's important, as you can see from our current show, that everything be about me in Washington, so I want to say this about me. I am the only person in the history of the United States who went to high school and to law school with people who won the popular vote and did not become president. I said this to one of the Democratic candidates, and he said to me, "Don't support me." And I did not mention this to Hillary because she would say, "You also are a Russian agent." After the last election, a group of us, after this happened the second time, a group of us got together and created this nonprofit, Making Every Vote Count, and we have joined in the cause that so many other academics and reformers here have been fighting for a long time, especially you, Rob, and so we stand on the shoulders of all of you. We've reached this conclusion. The problem in our time with this system is that it causes the two major parties not to compete for every vote everywhere. Napoleon said that to understand somebody, you have to see the world the way that person saw it when that person was 20. So when I was 20 in the 1960s, the parties actually did seem to compete everywhere. In the 1960 election, there were 16 states in which the margin was less than 3%. And in 1968, there was also an extremely close election. The inequities, the unfairnesses of the system were masked by the fact that the candidates really did go back and forth across the whole country. California was a swing state. Texas was a swing state. So in that era, it wasn't possible to see the flaws in the system. But now, in the year 2016, the margin was less than 3% in only 8 states. And the District of Omaha, they had 98 electors, but of those 98, 56 were just in the swing states in the Great Lakes. Now, you saw that in Larry's map. But you should also know that in 2012, the Obama campaign only polled in 10 states in the United States. There was a lot of talk about visits. Visits is a proxy for attention, but the really important point was made by Larry earlier. People laid their policies out to appeal to the votes in the states that are the swing states. They govern in their first term. In order to do that, you can think of many explanations for the bailout of GM and the additional bailout of Chrysler, but without any doubt whatsoever, the Electoral College was one of the explanations. You can like it or you cannot like it, but you can't deny that that wasn't a major factor. And there are lots of industries and lots of workers and job classifications in other parts of the country that never get any attention whatsoever. As a result of this focus in such a small number of states, you've heard the numbers, but basically more than 80% of the population is taken for granted, and that's the same thing as being ignored in the general election, and then on into the election, and on to the governing process. It means that at most, about 15% of the population decided the outcome. Let's talk about 2020. In 2020, in all probability, Donald Trump will lose the national popular vote. He is governed in a way that is quite rational. Hard to say that word in the same sentence as Donald Trump, possibly, but not when it comes to election strategy. He is governed in a way that utterly ignores the national popular vote and focuses entirely on an electoral strategy. And here's the strategy. It's called hop, skip, and jump. He has a pretty much guaranteed base of 230 electors. If he does not have that 230, then it's going to be a landslide for the Democrats. So unless it's a landslide, he has 230. If he gets Florida, he now has 259. That's the hop. The skip is to win in Wisconsin. 259 plus 10 is 269. And if he wins Omaha, he gets 270. Hop, skip, and jump. Don't think that this hasn't already been thought in his campaign. Specifically, the president has targeted Joe Biden for defeat in the Democratic primaries because he thinks that Biden would win Wisconsin, and he believes that he, Donald Trump, would beat Elizabeth Warren in Wisconsin. And that explains the Ukraine story. There are at least three deleterious consequences to the system's focus on a few voters in a few states. First, the policy preferences of the vast majority of Americans are rejected by Republicans and not adequately pursued by Democrats. These include, but are not limited to, the following desires reflected in the polls by 2/3 or more of Americans. They want to see the government lead a victorious battle against climate change, against widening income and wealth inequality, against unaffordable and inadequate health care, and against xenophobia and racism. Those are the policy preferences of the vast majority of Americans, and they are not reflected in the Republican Party, and the Democratic Party, when it has power, does not adequately pursue them. Second, by taking for granted the outcome in 40 or more states, the two parties do not compete vigorously to drive turnout in those states. As a result, participation in democracy in the United States is lower than in most democracies. If they competed for every vote everywhere, turnout would go up by between 10 to 30%. That is an additional 15 to 45 million voters. The electorate would be less white. It would be younger. It is likely that these newer voters would then have more faith in our democracy because the parties would be asking them to participate. And the parties would correctly be telling them, your votes matter and your wishes matter. Third, the system creates a huge incentive for the Republican Party to present itself as the party of whites and males, and quite specifically, as the champion of evangelical white Protestants. It was not always so. You heard this at lunch. You heard it from someone who was in the meetings. This is because 30% of the voters in the swing states of the Great Lakes are evangelical white Protestants. The system also appears to reward the Democrats for cultivating a base more heavily weighted toward women and minorities than the total population. And arguably, that lures Democrats into ignoring the economic and social concerns of whites in other states. This system, in sum, has excluded most Americans from full participation in the choice of the president. It has skewed the party's policies and popular bases in ways that have exacerbated social divisions. Elections always seek to exploit social divisions, but in governance, everyone discovers that those divisions are obstacles to useful collective action. And third, the system is racist and sexist in its effects. If you agree with me so far, you will agree that the goal of reform is to force the two parties to compete nationally to win a national vote count. And Larry's amendment is a brilliant idea. But I would like to offer my specific minor gloss on it. The Vaca strategy, the idea of this amendment, any other version of this amendment, it's all about forcing the parties to recognize that they need to negotiate to change the system. And there are many varieties of the way that negotiation might go. The National Popular Vote Interstate Compact is a reform that would force the parties to compete everywhere for every vote. Here's what would happen. They would raise more money. They would spend it along a rising marginal cost curve weighted by the likelihood of persuasion. Sam, you'll have to help me out with this mathematically. Until the predictable total for each party reached a clear majority. It does not mean that they would compete equally, Republicans and Democrats, for the exact same vote. No Republican is going to spend money advertising to me on Facebook, because it says right on the Facebook page for me, don't do that. But there wouldn't be any voter in the country that one of the parties wouldn't try to reach, and there would be many voters that both parties would try to reach. But the compact's problem is that it cannot get to 270 electors unless a few swing states or red states switch from winner take all to the compact. Now, we've done a lot of polling. My nonprofit, we have polled in North Carolina, Connecticut, North Dakota, Colorado, and nationally, just within the last 12 months. In every single state, that's where I mentioned a lot of different states. In every single state, between 2/3 and 3/4 of the electorate tell pollsters that the national vote winner should always be president. But the professional politicians in the swing states tend to like the attention that comes their way from being in swing states, and they especially like the deep-pocketed donors who they meet at least every 4 years. So Democrats and Republicans in elected office in swing states really ignore the will of the voters, even in those same states, and they tend to oppose the compact. There are two ways to overcome this problem. First, put the compact on the ballot. This is possible in 26 states. Their ideal targets are Michigan, Ohio, Arizona, Utah, and Montana. If this compact were on the ballot in Ohio when the voting is held on November 5, that's in 17 days, it clearly would have passed. The polls already show that. It clearly would have passed. The reason it is not on the ballot is lack of money. The cost of getting on the ballot in all 5 of the states I mentioned in the aggregate is $15 million. The cost of waging an effective campaign for winning would be another $50 million. That's $65 million. That is 2% approximately of what will be spent on the 2020 election. That is also less than the money raised so far by the Bernie Sanders campaign for president. So we need to find that money. The other way for the compact to be passed is to wait for a Democratic landslide to sweep Democratic majorities into control in a number of state legislatures and governorships, and that is the low-cost strategy. Either way, the compact will face well-funded right-wing legal challenges. So what I want to say in conclusion, thank you for the notes saying that I'm concluding. What I want to say in conclusion is that as these legal challenges are making their way through a Republican-tilted federal judiciary, the way to win these cases, or the way to maximize the chances of winning these cases, is to have great facts. So if the compact just barely has 270 electors, that is not as great a fact as if the compact has 330 or 350 or 370 electors. If the compact only went into place because the Democratic legislatures happened to exist for a short period of time before the pendulum swung back the other way, and they managed to ram this through, that is not as good a fact as compared to, suppose 5 or 6 states had ballot measures and the people voted to actually pass the compact. That changes the dimension for a court that is going to think, a Supreme Court that is going to think, there are limits to the degree that even we want to stand in the way of what the people want. And one more thing. If there were just one election in which the national popular vote actually got the president elected, that those were the rules, the people would revel in that. They would revel in it all across the country, and the Supreme Court would not, in my view, be able to stand up against that and say we're going back to the old way. So consequently, this is the real conclusion. Thank you for indulging me. So consequently, it's a really good idea. Well, you called them shortcuts. I would call them leverage points. It's really a good idea to think of leverage points that actually could, just because of the composition of the political system at a given moment, just happened to be able to cause the national popular vote to be determinative. Here's an example, and I'll conclude really for real on this. So it's possible to put on the ballot in North Dakota in June of next year and in the District of Columbia next spring of the following. We in North Dakota will allocate our electors to the national vote if some state that always, or jurisdiction that always votes Democratic does the same thing. Well, that would be DC. It could be Maryland. It could be a whole number of different states. That's only 3 electors. We polled this in North Dakota. It wins by about a 15% margin. When you run the positive and negative messages against it, it is, hold on to your hat, a toss-up in North Dakota. Why? Because in North Dakota, like every other state in the country, the people believe the person who wins the national vote should always be president. So I told you the hop, skip, and the jump. The hop, skip, and the jump, the Trump campaign would fall flat if it didn't have that 3 extra votes in North Dakota. Now you're thinking, this is a short circuit, and you're absolutely right. And it would get a lot of attention, and that is really great. And what if we pulled it off? Then it would be the case that whoever won the national vote in the year 2020 would become the president, and that's where we started. Thank you.
Well, we've got a little over 20 minutes. I've got 20 questions, and I'm sure the audience has some questions, but I want to give each of you up to a minute if you want to respond to something someone else has said. If not, I can launch right into my questions.
I'll just be super quick. So one is, I think when I was explaining MPV, we got through it, but it doesn't kick in until you have 270 electoral votes. And that's going to sort of be the issue with the Reid proposal, because it doesn't have that kind of guarantee of the popular vote winner always winning, and that sort of has been a key part of the strategy, but it's a key part of explaining the compact that I actually didn't say. But I wanted to sort of say just on the, it sort of relates to the more perfect union point, Derek. It really is like, these are criticisms that are valid, and yet I think that when you stand up against the other half of 34 states being intrinsically out of play, and I would say that's true, it's like, they're disproportionately rural states, right? Like it's affecting real people. I also think the point I think was alluded to that Guy Charles, I guess I was talking about, it's like if you're having a popular vote, you're going to work through the state parties. You're going to invest in the mechanisms that exist to get votes out. And I think it actually would be like a party building exercise having the system.
Amel, you were good.
I just wanted to address one thing because it's come up in every session and every presentation, the issue of the imbalance of swing voters and the imbalance of voting power, which I think is another area where it's easy to fixate on the Electoral College and it's easy to fault the Electoral College when essentially this is a function of party strategy. So, there will always be voters that have more power. So, for example, median voters have more power. The most dispassionate, disinterested, ill-informed tend to shape party platforms. That's a function of party strategy. There will always be party strategy. There will always be voters that get more attention because resources are limited and parties want to win. And I don't think you remove that by removing the Electoral College. You're going to shift it. So it may not be these swing states or it may not be these swing voters, but you're not going to eliminate strategic behavior on the part of parties.
So I have a number of legal questions related to using the initiative power to change Electoral College votes when Article 2 says that it's the the legislature that choose elected. But I don't know that this is the forum for that, but I just want to flag that that would be a major question that would end up being resolved by the Supreme Court. I want to instead focus my, I guess, two questions on the practicalities of this. So if national popular vote moved out of, the academy and into the real world, one of the things that concerns me the most is that there's a provision in it that says no state can withdraw from that compact within 6 months of the election. And yet, the Constitution also says that state legislatures get to direct the manner. And so imagine Trump 2 is winning in the popular vote in the polls, but California has Clinton 2. There'd be tremendous pressure on the California legislature to withdraw. So that's one question I want to put on the table. How do you deal with this 6-month withdrawal problem and the fact that the compact could politically unravel? And the other goes to Larry's point about the faithless elector lawsuit that he's bringing. He's hoping that if the Supreme Court rules that electors have discretion to vote their consciences, that it would spur activity towards enacting either a national popular vote or an amendment. I'm wondering how realistic that is as a political matter. Would it have that effect or would it not? So open up both of those questions.
I mean, I'll take a stab at the second one. I'm not as worried, well, I shouldn't say not as worried. I don't think the risks are any sort of greater or worse for national popular vote in terms of faithless electors when it comes to, with that versus the status quo, right? I think the way the system is going to work, by the way, in terms of the national popular vote, it's not like there's one slate of electors and they're pledged to follow the national popular vote. It's that if there's a Republican slate, there's a Democratic slate in your state. If a Democrat wins the national popular vote, regardless of what happens in your state, the Democratic slate is the one that gets selected. If it's a Republican, the Republican slate. So there's already going to be that built-in affinity or loyalty, I think, from the electors, despite whatever happens in the state. So I think that there's no question that there's increased pressure now or interest in having electors sort of consider that role. I think the parties are going to respond in kind by 2020. I'm not sure that there's that it changes the calculus very much. On the flip side, because the national popular vote requires 270 states to join in and compact, you need 270, so you get 270 automatically. And then whatever happens in the rest of the states, some might go Republican, some might go Democratic. In a way, you very rarely, I think, are going to see a 270, 268 kind of situation. I think you're going to have a handful of other states that come along with the compacting states, and therefore you actually increase the likelihood of what we might call landslides in the Electoral College of 350 electoral vote margins on a fairly consistent basis. And the greater the margin of victory, the less concern there is about faithless electors.
Can I just emphasize that point? You're exactly right. This is why, if the Supreme Court does what I think they will do, one solution is the national popular vote, right? Because the solution of the national popular vote will create a large margin, so you don't have to worry about one or two electors. That's the motivation.
If I want to respond, 6-month withdrawal point?
Yeah, and I'll just add, and I think you were sort of talking about the politics of the proposal. I think there will, it's been sort of a sad reality that Congress is just not looking at electoral college reform, the whole gamut, like even just how to deal with contingent elections. Like, come on, folks, like do your job. And so this may trigger some real serious work and thinking. It sounds like it will. I would say on the compact clause, I mean, part of it is there's sort of theory and possibility. Going back to 2000, we got really actually first really involved in this issue. This is before the compact, but just the idea of direct election, because we were nervous that there would be a Gore victory in the Electoral College and losing the popular vote that would trigger a whole conversation about direct election. And we wanted to make sure ranked choice voting was part of that conversation. So we sort of got out front with John Anderson and others. And so it's really hard to anticipate, even like 3 days before the election, whether you have a better chance to win the popular vote or not. So there's sort of like like if you go to Every Vote Equal, which I hope people can find that online, and it kind of goes through, in great detail, at least one way to answer a lot of questions in great detail, and I think very informatively. But you can argue the points in them. But it goes through. There's like a whole 7 issues on how this isn't a problem. But I think politically, just on that alone, one, it's hard to pass laws quickly. It's hard to know you really need to, and the voters actually like a popular vote. including in California. Like, so if you were expecting Californians to say, you know what, we're going to give up on winning the popular vote and make your vote meaningless again because it might help our nominee or something, I just think politically that just isn't sound. It just isn't likely. One, it's hard to do, but it's also just simply against the expectation that will have been created, that we're going to finally have a popular vote election, and then some like crass party is thinking that can somehow jam through something on a probably wrong prediction about whether their nominee might be helped.
Okay, so we'll open up to the questions. Guy?
Yes, quick question that might be directed toward Derek, but for anybody, which relates to the Bush v. Gore type of a problem, which is that different states have different rules for vote counting and stuff. And the question for me is whether something like the National Popular Vote Compact or something like it doesn't create like a virtuous circle by incentivizing states to create the best rules of political participation because they really want to be involved, right? And want to make sure that, especially they're part of the compact, that they get the full benefit of their citizens participating. So I wonder if we are in fact going to see the types of disparities that one might worry about, and in fact what we might see is less variation and more uniformity as a consequence of states adopting best practices as a function of just the virtuous circle that is created by something like this. So it doesn't necessarily, you don't have to necessarily answer that, but just your thoughts or anybody else's thoughts in the panel on that issue.
No, yeah, I think I'm not great at future casting these things, but I think there's also risks. So I think there are risks the other way too, right? So you can imagine Florida's. It's a maybe. Is that the right? So you can imagine other situations. So if a state, so Iowa was looking at enfranchising felons, and it's an exhaustive process to amend the state constitution there. And you can imagine the debate changes a little bit if we're no longer sort of looking at Iowa. All of a sudden, people are looking around saying, "Wait a minute! If you enfranchise felons here, that now affects the national popular vote, and all of a sudden there's external influence to maybe restrict or constrain decisions that might have otherwise been in the state." So I'm not sure, it might be, so whichever way you define your race to the top or race to the bottom, right, there might be ways in which states want their own citizens to have more influence in the process. That's, I think, precarious on the one sense that we don't know what the future holds in terms of partisan affiliation. But I think it's also uncertain in the sense that this assumes sort of more of a state parochial interest rather than a partisan interest, right? And to the extent that the ruling party is less interested in enfranchising a certain other set, maybe they're okay with it in state because they feel like the margin's safe, but not so in national elections. Now, maybe in presidential elections, that would be the tail wagging the dog, right? That whatever rules they're coming up with in the state are really going to be about the statewide elections, and we're concerned about the gubernatorial elections, the congressional elections, more so than the presidential elections. Yeah.
Let me just sort of say, as a thought experiment, if we'd had a popular vote since 1830 or something, I think there have been some failures in our electoral process along the way that have had some unfortunate outcomes for the country, like the Civil War, that one can say could have been resolved politically, perhaps in a different reality, right? You can have a whole conversation about whether that's true or not, but it certainly didn't work out very well. But the fact of it. But imagine we had a popular vote. Could Jim Crow have been sustained? Could we have looked the other way for 70, 80 years if a whole slew of states were disenfranchising that many people? You can look away if it's only affecting people in that state. You shouldn't look away, but the national parties did. But if it was all part of one vote, I think it would be a lot harder to sustain those kinds of practices than the sort of race to the top.
Derek, I just want to follow up on your earlier remarks and your answer to Guy in terms of the equal protection argument. And Larry made it too about Bush versus Gore and equal protection within jurisdictions. Does it really apply across states, especially when Article 2 of the Constitution says that each state legislature gets to pick the manner? So I assume that they could say, whoever is the winner of the Fox News poll the weekend before the election gets our electoral votes. I assume that doesn't create an equal protection violation. So why can't they say whoever is the winner of the national popular vote? Why doesn't Article 2 solve your equal protection problem?
It didn't solve it in Bush versus Gore, even though so it's a single constituent.
But that was a single jurisdiction.
No, that's right. But I guess I'd have to think about to the extent that we would come up with a national public vote and say we take each state's totals and we have no concerns with sort of the cross-state effect that might have. I mean, I don't know. I have to spend more time thinking about how that works in terms of cross-state boundaries and running the electoral, in terms of equal protection issues. But I think there seems to be at least some concern that counting the votes in this jurisdiction that way, but in that jurisdiction another way, simply because you've agreed to do so. I mean, there are lots of ways we can agree to do something and still run afoul of the Equal Protection Clause, even within a single jurisdiction or single constituency. But I mean, I'm just repeating the question. So.
Yeah, Jesse.
Why is it not a problem?
Speak up.
Why is it not a problem right now if we're pooling together electoral votes from states that have different franchise requirements? Why is that not the same?
Right, so it's because it's 51 separate contests. You're all just picking your electors. So California's picking 55 electors. They can do whatever they want with them. They can throw them into the ocean if they want, or they can send them to Sacramento as a slate of Republicans or Democrats. In the same way that what we do for the Senate, 50 separate contests, you elect your 2 senators from each state. In fact, I think Larry's proposal at lunch actually sort of embraces that system in that it's 1 vote in Wyoming, 66 in California, and you kind of do whatever you want within that sort of framework. So when you're within the state boundaries, undoubtedly at the end of the day, all of them are getting together and making an aggregate decision, but we're electing the appointers separately, and then there's a second stage where they're making some kind of an aggregate decision at the end. So because there's that intermediate stage where the electors are acting, that sort of changes the nature as opposed to looking across all 51 jurisdictions. Say, okay, now this is how we're going to count them up. This is how we look at the votes.
Yeah, Alex.
I can see a lot of ways, now, I'm personally supportive of the idea of the compact, but I can see a lot of ways in which it ends up in a mess. Right? I mean, there are all sorts of legal messes, all sorts of legal suits, and then I have my own particular, probably horse which I'll roll in for 5 seconds, which is that I think it's inherently unstable, even if you get to 270 or whatever, because I can easily see some states where the vote went against them, deciding, okay, after the election, now we're out of the compact, and then we're going to have different rules for different elections every 4 years, and that's how we ended up with where it's the in the first place. So, my question here, maybe it's mostly for Rob, but not just for Rob, what thinking is going on as we approach 270, hopefully we will, about how to transition the effort for a compact into an effort for an amendment? It seems to me that's a plausible place we're going to land, and I haven't heard about anything. And I don't know what you call that.
Well, I'll answer in 2 ways. One, almost just in the same way that the ruling on faithless electors will sort of trigger a conversation on Congress. In the coming passage of the compact, the conversation about consent, people having these conversations about whether it's the best way, it'll have an impact on Congress, whether it needs to or not. What's been a kind of important insight for me is that as this became a significant bipartisan push, which on the ground it is, and there's incredibly passionate, strong Republican conservative advocates of national popular vote, they do not want an amendment. It's fundamentally important to them that this is about keeping state control over how we pick the president. And they like a national popular vote for president. They think that has all the positive impacts we're talking about, but they would oppose an amendment because they think that keeping state power and control is an important right in the Constitution and they want to keep it there. So I think that there would be a division, at the very least, in the national popular vote community about that.
Ned.
Reed, this question for Reed. I'm thinking about your proposal of North Dakota and the DC just pairing up by themselves. And I'm imagining a situation in which Trump is the plurality winner of the national popular vote, say 48%, and Elizabeth Warren, let's say, is runner-up in the national popular vote at 47%, and some combination of third, fourth, fifth candidates gets the remainder, and there's a pretty confident view that had there been ranked choice voting or just a top 2 or something, that Elizabeth Warren would have leapfrogged over Trump. I can imagine people in DC a little bit nervous that perhaps they were the ones that free electoral votes that through the election to the national popular vote plurality winner, if perhaps, because it might not be North Dakota's votes that stopped Trump getting electoral college majority, and for the very same reasons you're saying that the electoral college is on the ninth edge, it might be that DC has just thrown away its electoral vote that would have given Elizabeth Warren the electoral college result, and that mirror image scenario doesn't seem so palatable to residents of DC or any other Democrats who might be politically sympathetic with that perspective. Okay, your response.
I'm willing to bet that Donald Trump loses the national popular vote by a really big margin, 5 million, 6 million votes. And if the parties competed for the national popular vote, he would lose by 7 or 8 million, meaning I don't think it's a close question. It's okay to imagine hypotheticals, but since you're responding to the thing I laid out, which is what could you do right now, I think anybody would say, okay, if you don't want Donald Trump to be reelected, does your risk lie with the national popular vote scenario, or does it lie with the electoral college scenario? And anyone would say, well, of course, his strategy is an electoral college strategy. So if there would be a way to derail that, any way at all, that would be ideal. In Ohio, we almost persuaded, but didn't succeed, almost persuaded people to put on the ballot, because you were involved, thank you very much, the following measure, which is Ohio all by itself would allocate its electors to the national popular vote. Well, working with Sam and others, we built an election model. For every elector in the solid Republican base that's allocated to the national vote instead of the state plurality, you subtract 2 percentage points from the probability that the Republican wins the electoral vote. So if you think Trump is 50-50 in the electoral college, and you take Ohio's 18 and you allocate them to the national vote, then you subtract 27 points from the 50, and now his probability of winning the electoral college is 23%, which is a lot less than 50. What I'm saying is a bold move by one state or two states in the elections that Sam has already told us, we have a pretty clear but troubling odds of repeating again and again. A bold move by just a couple of states could cause any particular election to be one that is determined by the national vote. My answer here is don't let perfection be the enemy of good. If we could have one election that was run according to the national popular vote, there's so much that changes in the system to make that happen, and it is so unlikely that then it changes back to the dreadful system we have. That would be a leverage point worth exercising.
Okay, we've only got 2 minutes, so Sam, can you ask a very quick question?
So I think all these things are hard for us to not view through the lens of 50-50 elections. And it must have been very hard to imagine getting out of that during the first Gilded Age when there were 5 close elections in a row. And McKinley and then Teddy Roosevelt got us out of that. So I'm hearing all these objections. So I think they sound different once we get out of 50-50s. Democrats' insistence on urban elections, if the nation is 55-45, that doesn't look so bad. Because it goes beyond urban coalitions. I heard Derek Muller's litany of possible things that could go wrong, and honestly, viewed through this lens that I'm describing, to me that sounds like an exciting laundry list of things we gotta do. I'm a laboratory scientist. When I hear someone complain like that, I'm like, yeah, baby, now we know what to do. So, no, I mean, it's serious. Like, to me, that's like an exciting mountain climb. So I just want to back up to 2028 or 2032 and ask the question, in some scenario in which we have a national popular vote, are there specific action items here that would be really genuinely hard to overcome? And I'm just trying to figure out which of these are, and Derek came up with a really good list of things that can go wrong. You see, what's an insuperable problem?
Well, please keep your answers brief because we're out of time.
I think the question is how much variation or disparity we're willing to accept between jurisdictions, right? Maybe we don't mind so much that there's a wide divergence in terms of ex-felon voting, or there might be wide divergence in terms of ballot access rules. Maybe that's okay. Maybe a simple constitutional amendment, or much more simple, empowering Congress to have a times, places, manner regulation would allow for that uniformity. Maybe there can be that kind of leverage that exists by regulating the federal congressional elections. States now have a high incentive to match their presidential elections. There's no question that there's ways we can think about it. I'm saying these are the concerns we have, and that we need to sort of accept that there's a lot of variance and disparity without sort of additional intervention, additional steps beyond sort of just passing the MPV.
All right, it's now just about 3:30. The next and final panel will be at 3:45. So please join me in thanking our panelists.